letting people in. Yeah, I think you can start it whenever you're ready, Andrea. Thank you so much.
Right. Hello, everyone. I'll just kick things off very quickly to just speak a bit of the experience that went into from the NLSIR board side. My first introduction to BS Chimni was in my third year, I think around 1 year ago, when I took my first public international law class and we were taught the TWAIL manifesto. And I remember that being quite an eye-opening sort of thing to read. I was introduced to Professor Sornarajah when I took Harshad Pathak's course, who's a panelist with us when I was writing a paper on international investment law. And Vasuki Nesiah, I was introduced to by Professor Rohini Sen. And I am not the chief editor that the project began under. That credit will always be to my predecessor's name, Kopal. She's in the attendees today. But I was sort of the one who saw it through with a lot of help from the person who originally conceptualized the idea and sort of brought all of this galaxy of authors together. My junior and friend Bharat, who, even though he's not with NLSIR anymore, having moved to a different journal, still continued to remain a part of the special issue series through. On behalf of the NLSIR Board of Editors, very warm welcome to everyone, to all the people who are attending across the world. I know for a fact that we have an international audience in terms of panelists and the audience. And I'm just going to hand it over to Bharat to talk about the motivations and vision behind the special issue very briefly, and then we'll go into the discussion immediately.
Hi, my name is Bharat Arjun, and like Shreyas had mentioned, I belong to the previous NLSIR board, and we had sort of kickstarted the whole process of this special issue coming through. And I'll be mindful of not taking too much time so we can get into the substantive bits of it. But the project does owe a huge debt of gratitude, intellectual and otherwise, to so many people, and I think that that'd be a good place for us to kickstart with as well. Now that I see what this project has come to, I think the first thing that really strikes a lot of us is the sheer diversity of people we have. And this diversity also went a lot into how this came to be conceptualized. A lot of contributors, peer reviewers, some of them who are not with us today, and many, many more people, support persons. In terms of conceptualization, the real birthing point of the special issue, in fact, began with a small conversation I was having with Professor Chimni. She had expressed interest in responding to a piece that preferably was from an Indian journal on the topic of jurisdiction, universal jurisdiction, extraterritoriality, other things. And at that point, many of us on the board were interested by the idea of creating some cross-cultural conversation on this topic. I remember surveying many journals in India during that time to come up with an article that would be meaningful to her research interests as well. And what really struck a lot of us, and I remember talking to Kopal extensively about this, was the fact that we don't have a lot of academic spaces where this conversation generators are really creative. And Professor Chimni, to echo Shreyas' sentiment, a lot of our initiations from India as well as the global south to critical international law do come from Professor Chimni himself. And I remember finding the article that is the centerpiece of symposium today then, and sending it over to Professor Chimni. And then began this whole process. And at that point, we were all excited by the idea of creating a symposium where this could be replicated on a large scale. People can come and discuss their own perceptions of international law. And then the obvious choice then was to bring TWAIL in conversation with this as well, because, and that's how I began conversation with Professor Rohini Sen as well. We happened to be in conversation through a WhatsApp group on international law that she had started, and a lot of people from the group are here today. And we remember discussing this, and Professor Rohini had told me at that time, publications really only become academic discourse when people engage and interact with this. And many of us on this board had a strong sentiment that there was a gap between critical legal theory that comes from many spaces, as well as mainstream conversation of international law. And specifically from a nation in the global south, a student and journal in India, we thought it'd be extremely meaningful for us to create a discursive space, a very ambitious project we had at that time to create a discursive space And what followed was obviously a lot of support, a lot of conversations we had with Professor Chimni, Professor Rohini Sen, Professor B.S. Chimni himself, who indirectly spoke a lot to us about his excitement about a student-led project. And Kopal, the chief editor at the time, was very supportive of the initiative. And I had the privilege of drafting the concept note, organizing it at the time, which Shreyas saw it. And as most things in academia, this was also delayed quite a bit. And Shreyas came in and saw it through as well. So our board was low to his board as well. And to conclude with, I think the main sort of vision a lot of us had, and what it came to be is really celebrating the diversity of international law, creating discursive spaces where we can come to understand each other better, what international law means to each of us from our own personalities, where we come from. And I think the biggest sort of celebration of this is the symposium that's happening in front of us. Professor Vasuki, Nesiah, Professor Sornarajah, Professor Chimni are people I have read in class, read otherwise, and have been hugely inspired by. So just to have this platform to see all these people is in itself very meaningful to a lot of us from India. But I'm also hopeful this goes on to mean a lot. This becomes a conversation generator for many, many, many more conversations. Professor Shaman Keetner carried this forward to the panel in the American Society of International Law. And just to see the impact it can create is a very joyous occasion for a lot of it at National Law School. And to conclude, I think there is one big thing that we wanted to promote. Process N had been very passionate about this as well, to create a space for all kinds of people. We have students contributing in special issue. We have undergraduate students. We have PhD scholars. We have names which are authorities in the field of international law. And to see all of them in conversation itself is a big thing for us. And also the kinds of articles. We have articles on legal history. We have articles on private international law, investment arbitration. And we also have articles on an article on space law. So just to see what a concept like jurisdiction can mean to a lot of us coming from different spaces is something really special. And my hope for the symposium is also that it becomes a space where we can have reasonable, respectful disagreement, discourse, understand each other a little better, and really bring different conceptions of international law closer together in an academic discursive space. And again, this owes a huge debt to people who have contributed, people who have helped us, and people who ultimately will carry this through. And it's a privilege to be here. And we really look forward to what this becomes. Thank you.
Thank you so much for that very, very generous introduction to the symposium, Bharat and Shreyas. I will not take up much time. This was meant to be a very intimate gathering of the contributors to ideate, to speak about each other's papers, and to see whether the ideas would change or remain the same post the symposium. So my framing the discussion remark has been prepared keeping in mind the small audience, but unsurprisingly, because of our contributors, because of what we are about to talk about, the number of participants has far exceeded our expectation. Thank you, all of you, for showing up here, for taking the time, the energy, and the commitment to be here in different capacities. We also thank those that could not be here today. A couple of our contributors could not join us today, but they have been present and they'll continue to be present through their symposium contributions. TWAIL as a praxis is mindful of both form and content. It tries to go beyond liminal notions of institutional knowledge, production of such knowledge, academic excellence, what are the valid sites of knowledge making, expertise, hierarchy, values, so on and so forth. With that idea of TWAIL in mind, I wanted to emphasize three defining features of these symposium, some of which Bharat has already touched upon, but I wanted to TWAIL it precisely because it's a TWAIL symposium. First, this has been a journey of goodwill made in good faith. Almost all of our contributors are here with an intention to engage in good faith with Professor Chimni's work, with TWAIL. They are here on account of the goodwill either exercised through the editorial team or by Professor Chimni himself or through the TWAIL community that has been built over the years. And at a time where we think meaningful conversation between mills and TWAILs may only be possible in limited capacity, this symposium has been anything but. It's been an exploration of how such dialogues can happen, how labor can be dedicated to that, and how a very, very generative account of such dialogue can be produced in the form of a written symposium as well. The second dimension, the second TWAIL dimension of our symposium is the collaborative and non-hierarchical nature of the work that has been done. There are, of course, limitations imposed on each of us due to structures and structural academia, but I think I speak on behalf of everyone when I say each of us, every single member of the editorial team has donned on different hats of editor, reviewer, copy editor, troubleshooter, firefighter, whatever the need be at any given hour of the day in true TWAIL spirit. And the third, again, the same vision that informs our contribution is where we give a gentle nudge to widening our understanding of ideas of expertise and scholarship. This we hope to achieve through meaningful dialogue between different kinds of panelists at different stages of their TWAIL journey. If you look at our symposium contributors, as Bharat has pointed out, we have senior TWAIL scholars in dialogue with younger TWAIL enthusiasts, and we've done this in as non-hierarchical a way as possible. Now, before we move on to the symposium discussion, I wanted to foreground a couple of things. My foreword, which I titled The Troubles of Introducing a Discipline, has been an observation of the various ways in which we engage with TWAIL and the different capacities in which we do so. I titled it The Troubles of Introducing a Discipline because it struck me that engagement with TWAIL across different institutions, across different spaces, has produced a certain kind of thinning of its archives. I say thinning because this process leads TWAIL to lose some of its archival value, some of its texture, some of its nuance. This thinning is somewhat inadvertent because of structural reasons and also because of where we put emphasis in terms of knowledge production and manifestation of TWAIL. What I chart out in greater detail in the foreword, I will present to you in two broad ideas here. This thinning occurs in two structural modes. The first I call the production of TWAIL mainstream and TWAIL periphery, where TWAIL mainstream is a circulation and recirculation of popular TWAIL text, especially texts that could be determined based on the kind of journal they've been published in, the kind of scholars they've been published by, or the kind of institutions, specifically geographical location of institutions where they've been housed in. These texts have inadvertently taken on a dominant characteristics of representing TWAIL, whereas other more contemporary but equally valuable and rich TWAIL contributions, textual or otherwise, often get lost in the discourse. The second structural thinness occurs through two terms that I denote as TWAIL inside and TWAIL outside. I use scare quotes to denote these terms because inside and outside is not a simple affiliation to a project, a particular sensibility that only comes through lived experience, or a certain kind of intellectual rigor produced only through academic texts, academic discussions, and debates. Inside here is the sensibility coupled with a certain kind of temporal affiliation to the idea of TWAIL. Whereas one has spent some time with TWAIL, with its various dimensions, with TWAIL adjacent scholarship, the different forms of interdisciplinarity it looks to exercise, and then one looks to mount one's critique, one's disapproval, one's engagement or disengagement with the idea. These two ideas of mainstream and periphery, and inside and outside, have proliferated a certain kind of thinness, which we have hoped to restore through our symposium. So in the next part, to mitigate some of these concerns of the thinning of TWAIL, what we hope to do in the symposium or through the symposium is give you a demonstration of doing TWAIL. And we've chosen to do that through Professor Chimni's article, The International Law of Jurisdiction, a TWAIL Perspective, where the conversation is located in the international law of jurisdiction, and consequently, its very, very intricate relationship with imperialism, territoriality, where territory is a social and political process in as much a geographical location, the many forms of extraterritoriality from the period of high imperialism to the messy manifestations in modern day, including ideas of extraterritorial solidarity, the processes that imbricate the modern state and capitalist expansion through this idea of jurisdiction, and finally, subaltern internationalism, subaltern solidarity, and the different ways in which a non-statist vision of international law can be discussed through these ideas and processes. I stop here and I take you to our symposium and the first roundtable, which is the highlight of the day. Thank you so much. Our first roundtable is a conversation between Professor Chimni, Professor Sornarajah, and Professor Nesiah. We begin with Professor Chimni since he's also the author of our article. We move on to Professor Sornarajah and then Professor Nesiah. This order is simply based on the way the articles have been arranged in the symposium. Each of you have about 10 minutes, and then some questions will be posed to you by our panelists, and then we open up the discussion to our participants. Thank you so much. Professor Chimni, over to you.
Yeah, thank you, Professor Sen. A very, very good evening to everyone. I must begin by thanking a number of people, beginning with, of course, the National Law School, the NLSIR editors, Professor Kettner, Professor Rohini Sen, and all those who have put together this symposium. My heartfelt thanks to them. My heartfelt thanks also to all the contributors who have engaged with my article, which includes all those contributions, whether they are accepted or not in the symposium issue. I must also say that it's a great privilege and honor to have a symposium woven around one of my contributions, in this case to the subject of jurisdiction. Finally, I'm very, very deeply grateful to both Professor Sornarajah and Professor Vasuki Nesiah for also responding to the piece, for reflecting on the piece. These are two scholars I greatly admire, and I still, even at this late stage, aspire to emulate. So heartfelt thanks also to both of them. Now, just a word on why I began writing this piece. And the reason is in a sense, a mundane one. TWAILers were, it was suggested to TWAILers that while you have provided an incisive critique of the Eurocentric narrative of international law, and you've also presented a justice critique of modern international law, you have not sufficiently engaged with the doctrines of international law. Many of us felt that it was time to actually take up this challenge and respond in however preliminary a way to providing an alternative narrative to the modern doctrines of international law, of which the doctrine of jurisdiction is one. I'll be very brief in my presentation because I'll just take a couple of minutes because my article is out in the public space, and I think we need to give opportunity to to the large number of those who are present with us today, and of course to Professor Sornarajah and Professor Nesiah. I would first begin by emphasizing that the focus of the article is on the question of exercise of extraterritorial jurisdiction. But I want to sort of underline that it is not about one episode or one incidence of the exercise of extraterritorial jurisdiction over time. The whole idea is about locating the historical role of and the idea and doctrine of extraterritorial jurisdiction in modern international law. That's the principal aim. And the different episodes, whether that be about capitulation agreements or that be about the exercise of extraterritorial jurisdiction by the United States, or that be the different modern forms or even postmodern forms of exercise of extraterritorial jurisdictions, are simply meant to illustrate the thesis that I'm about to propose. If I've chosen to delve with one episode of another, That is only for the reason that I felt they best captured they best evidence the argument that I was trying to make. So that's very important for me, that this is not about any one of the episodes. This is about the evolution and development of the doctrine of jurisdiction over time and how we understand it. Four other simple points that I would like to make. So my argument is that the doctrine of or the exercise of extraterritorial jurisdiction can be understood as the outcome of the historical tension between what I call the logic of territory or the sovereign state system and the logic of capital, that is global, capitalism. And the tension is that while the logic of territory or the state system or an individual sovereign state is bounded, is defined by physical boundaries, as if it were, the logic of capital is extraterritorial by nature. Capital always wanders, capital always travels. And that is what distinguishes the logic of capital from the logic of territory. But let me take a step back. So my argument is even a more fundamental one, which is that I believe that these two logic, the logic of territory and the logic of capital, are the principal influences or the driving force of what I call modern international law, which could be dated back to, say, 16th or the 17th, 16th or the 17th, 16th or the 17th century. But what we find in the modern textbook, in the mainstream literature, in the mainstream textbook of international law, that the entire sort of narrative of modern international law, the entire discussion of the different categories which constitute modern international law are only on the basis of the logic of territory. And that is why if you turn to any chapter on the question of jurisdiction, you'll be simply told that there are these handful of rules which need to be applied when and understood in relation to the exercise of jurisdiction, whether it be the principle of territoriality or the principle of nationality, and so on and so forth. And then it would be added somewhat that there is an exception to this principle, which is the exception is the principle, there is the exercise of extraterritorial jurisdiction. In my view, and that's my argument, that this narrative is in a sense a falsehood, if I may put it, from a global South perspective. The exercise of extraterritorial jurisdiction is as fundamental as the exercise of jurisdiction. And this can be traced back to this tension between the logic of territory and the logic of capital. But the influence of the logic of capital on the development of modern international law does not appear on any of the pages of the mainstream of mainstream textbooks. Now, a very broad, before I go discuss the interrelationship between these two logics further, I think it'd be fair to simply explain what I mean by extraterritorial jurisdiction. And so as a working definition, I would define it as the power to shape the laws, institutions, and practices of jurisdictions of dependent and dominated states. That is, this is the power to influence laws and institutions and practices in what in what we now call the states of the global South. And this influence has manifested itself differently both in the colonial era and in the post-colonial era. But there's a more fundamental argument which I cannot spell out here today, that when we work with this binary of logic of territory and the logic of capital, we often miss out on the interface between the two, how the two logics influence each other. And for this, that's why one reason I went to the genealogy of both the emergence of the modern nation state and capitalism. And the story is fascinating, although very well known, that both the modern state and capitalism emerged at the same time in history. And in a way, they constituted each other. We know that that the search for larger legal spaces by what is called mercantile capitalism was at least one factor which contributed to the emergence of this nation state and the consolidation in Europe of a nation state from very, very small principalities that were present there. Now, my argument is not that logic of capital result is what made the nation state possible. We are aware of the range of other very, very significant factors, including the ideology of nationalism, map making, military competition, a whole range of factors, but capital. Now, the result was that from the very beginning, when the nation state emerged, it was always from the beginning a bourgeois state. That is always a capitalist state. And so it was one of almost its historical destinies that when capital traveled abroad, it was meant to travel with capital and ensure that it facilitated its operation in other spaces. In this case, in colonial spaces, and then in neo-colonial spaces. So, from a global South standpoint, our laws, our institutions, our practices have been influenced by this exercise of extraterritorial jurisdiction to different degrees over at least 3 centuries, at least since the 19th century. And when I described those 3 episodes, beginning with the capitulation agreements, the point was to connect the dots. But at the end of the day, it is all about present. And when we come to the present, we see that this exercise of what I call extraterritorial jurisdiction, defined broadly as influencing the laws, institution, practices in dependent and dominated nations, it leads to a critical loss of policy space. And I've tried to illustrate that intellectual property rights regime of TRIPS is the easiest example to give. International investment law, as I've learned from the writings of Professor Sornarajah, is another instance where there's a loss of policy space. In climate change, there's a policy space. I can go on. Law of the sea, there has been a loss of policy space. So that's the substance of my argument. One last final point. In my own scholarship, I've not been able to elaborate this in the article itself. I'm personally not satisfied in understanding modern international law simply through the prism of this global North and global South categories. I think there are issues there. And I have always said that we need to advance other categories, whether we need to use other categories to understand these relationships. The category of class is one that I use, but the category of gender, of race, so much talk of racial capitalism, and in our case, caste as well should be used. So my argument is not that we don't look at the global South nations and their exercise of extraterritorial jurisdiction. I'm very much for it, because my thesis is that the elites in the global South are now collaborating or complicit in that process of the exercise of extraterritorial jurisdiction. But I didn't have the space to try and explore the idea in relation to jurisdiction in the present article. I don't know if I've made sense. I've come after a very long day. Let me simply conclude by again underlining the idea that it's the descriptive element. It is the relationship between capital and jurisdiction. And my title of my article should have been, capitalism and perhaps jurisdiction, which is the centerpiece of my argument, and not any of the single evidence. The larger argument, of course, being, and that's that it is the logic of capital which defines nearly every aspect of modern international law. It often does it, of course, through, so I don't want to work with a binary, does it, of course, through the mediation of advanced capitalist states. But to ignore this, to sideline it, not to speak about it, not to mention it, as Derrida used to say, you can't mention it even, is what I have a problem again, because my sense is you cannot understand modern international law if you divorce it from the logic of capital. Thank you so much for your patience. I know I've already taken too much time. My sincere apologies. Yeah.
Thank you so much, Professor Chimni, for giving us that brilliant roundup of your article. And also, once again, our apologies to everyone on this side of the world. I know the timing is a little unusual, but so thank you so much for making it and joining us and being able to give us the presentation. We now move on to Professor Sorna, who will be the first to respond to the article. Professor Sorna, over to you.
I have little disagreement with Bhupender, with whom I have traveled for a long time on the same path. But on extraterritoriality, I have some minor differences, which are largely definitional in character. I define extraterritoriality differently and attribute the origins of extraterritoriality to a specific date. So I take the date to be 1944, the decision of learned hand in the Alcoa case, in which antitrust laws of the United States were applied extraterritorially. The date is significant because it was coincidental with the rise of American hegemonic power. And thereafter, of course, we see that the United States uses extraterritoriality extensively in order to impose its hegemonic power on the rest of the world. So my analysis of extraterritoriality is largely in terms of power. And of course, in considering that, I would exclude universal jurisdiction, which is not an area that is subject to hegemonic power. So a situation like genocide, for example, comes about on the basis of a convention to which many countries have agreed to. So hegemonic power is central to my argument, and resistance to such power is also an important factor in considering extraterritorial jurisdiction. So the framework that I have built over the years in considering extraterritorial jurisdiction is somewhat different to the analysis which Professor Chimni has presented. I divide extraterritoriality into two main categories. The first category is offensive extraterritoriality, and the second category is defensive extraterritoriality. By offensive extraterritoriality, I mean the use of hegemonic power in such a manner as to exert dominance and cause antagonism in other states against which such power has been exercised. Antitrust is an obvious example, and when it began, one must remember that the use of such power was not against the third world, but against the European states, against the United States in Lake Airways case, in against the European countries in the Swiss watchmakers case. So the incidents of early extraterritoriality have been aimed against not the global south, but against states which were in alliance with the United States. So it's a bit difficult to sort of brand this area as in terms of a north-south divide, because of the fact that many of the instances, like the exercise of extraterritoriality relating to the Securities Act of the United States, they were aimed largely against the allies of the United States, the European allies of the United States, than against the states of Europe. It's only when we come to matters like the imposition of exchange controls against China or against other hostile states that we find extraterritoriality being used in an offensive manner against the South. So incidents relating to economic sanctions again involve hostility, the use of power by the United States against largely countries of the South. The other factor, the other aspect of offensive extraterritoriality is the area that I have spent a long time studying, the area relating to the exclusion of the application of local laws to foreign investment transactions. So here we find the insulation of foreign investment from the application of local laws and the subjection of it to a supranational system. So a whole new system is created, laws are created to apply to it, and that would be an instance where you find extraterritoriality being applied, because the whole process, which is territorially based, is relocated from the territory of the host state into a system altogether different. So that would be an aspect of extraterritoriality. And in explaining it, I would, of course, use the exact terms that Professor Chimni has used of private power, expansive private power of the United States, creating new spaces which could be controlled by the application of what is presumed to be international law. As I seek to demonstrate, much of the international law in that area is created by subterfuges, a series of subterfuges that would involve the application of what are referred to as general principles of law or low order sources of law, like the awards of arbitral tribunals, most of which are biased in favor of the capital exporting state. So we find the creation of a whole body of new law, the lifting out of foreign investment transactions from the territorial state, and subjection of that process into subjection of that process to an entirely different system of law. A classic instance of power-based international law, an international law that is based to a large extent not on state power, but on private power. And I would say also, to use Professor Chimney's formula, that this is done with the help of the elite groups in the capital receiving states of the South. So vast amount of corruption takes place. And of course, one would find that there is a sort of an acceptance of this system by the elites of the global South. I have often wondered why investment treaties continue to be made despite a lifetime which I have spent. I mean, not only I, but many of my colleagues have spent trying to prove that the existence of investment treaties work to the detriment of the global South. But despite that, treaties still continue to be made. And the fact that they are made can only be explained on the basis of complicity on the part of the elites of the South. But going on, I must also say that there is this notion of defensive extraterritoriality, which I have suggested to advance. The idea that torture is subject to prosecution in any country, like and the resort to the Alien Torts Act by people in the South, like in the case of the Nigerian proceedings brought against Shah, though defeated, contain this idea that you should be able to have recourse to the courts of the Western states in order to get relief. I mean, that was done by India in the case of the Bhopal incident, where jurisdiction of the American courts were invoked. Also, there are other areas like money laundering or the prevention of fraud, the control of internet fraud or internet crimes like pornography. These are instances of extraterritoriality, which the use of which by big powers may help to the betterment of the smaller countries, simply because it's only the larger countries which would have the resources and the capacity to ensure that such harmful deeds are controlled. And another factor that I could indicate there is the responsibility of multinational corporations. Here again, we find that South Africa and Ecuador are engaged in a new project. And of course, this is an ongoing project of trying to impose responsibility of multinational corporations in situations that arise like the Bhopal disaster sometime back in India. And then the final point that I would like to make relates to the rise of India and China. Because as TWAIL scholars, people always continuously harp upon this idea of imperialism, the past misdeeds, forgetting that there are new oppressors at work. And two of them, China and India, are probably the future oppressors of the third world. And we see signs of that emerging in the case of China already, with China asserting control over many incidents in the global South, the giving of large debts, ensuring that the payment of these debts, that relief on the payment of these debts are obtained in exchange for controls that are given over ports and over other territory. We also find that both China and India take actions, including assassinations of so-called terrorists in other countries, like in Canada or elsewhere. So these are incidents which indicate that the emerging abuses of extraterritoriality are the two countries, China and India, which played such a prominent role in the Bandung Conference, which is ceremoniously described as a triumph of the third world in articulating concepts that are dear to TWAIL scholars. So one would have to sort of move out of this idea of imperialism being the brunt of all arguments to study newer phenomena that arise, like the use of hegemonic power, the need to resist the use of such power, when it is disadvantageous to the interests of the third world, and also the present need to resist some of the misadventures of rising powers like India and China. Let me stop there. Thank you so much.
Thank you so much, Professor Sorna, for that sharp and succinct intervention. We move on to you, Vasuki. You're still on mute, Vasuki.
Thank you. Great. Yeah, many thanks for convening us. I'm humbled and honored to follow Professor Sen, Professor Chimni, and Professor Sornarajah. In reading Professor Chimni's intervention, as always, I not only learned much from his work, but was also inspired, and my own intervention reflects this inspiration. I was inspired by two counts. Firstly, I was inspired by his methodological approach, in particular, how he brings a larger historical cum theoretical analysis into doctrinal analysis to resituate doctrinal questions regarding jurisdiction in the logic of capital and the logic of territory. This radically opens up work on black letter law, and it is a methodological move that shapes the entirety of my intervention. Secondly, I was also inspired by the specific substantive intervention he makes at the end of his piece, namely the call for a subaltern internationalism. And my presentation and my paper in this symposium goes to that issue, this question of subaltern internationalism. We are in a historical conjuncture where a conversation about the contours of internationalism is especially urgent. As Professor Chimni has argued, extraterritorial jurisdiction has been shaped by imperialism, capitalism, and the dynamics of their relationship. The radically vibrant forces of internationalism today is itself shaped by and a reaction to the crisis in the relationship between the logic of capital and territory. So thinking with Professor Chimni's argument for a TWAIL vision, my intervention begins with his genealogical critique of extraterritorial jurisdiction in ways that then build a path to the recognition of extraterritorial solidarities in defining political and legal personhood in international law. Against a history of colonial intervention, for many Bandung-era Third World nationalists, reinforcing the battlements of sovereignty and the borders of territorial jurisdiction seem like the path to post-colonial self-assertion. But as we just heard from Professor Sornarajah, today it may be a moment to rethink that move. Often leaning into third world sovereignty felt at that original time like the unavoidable defensive stance against rapacious capitalist and imperial forces. Yet today, the third world left is attentive to how the nation-state model can itself be a vehicle for neo-colonial domination. Bandung-era optimism about the nation-state has given way to an interrogation of the normalized framings of basic label concepts like territorial sovereignty, how we mobilize them, and the histories we tell about these derivative institutional forms. In our contemporary world order, the nation-state is too often a Trojan horse for the world's most powerful players. Again, I'm just echoing Professor Sornarajah as well here. As noted earlier, Professor Chimni ends his paper by calling for what he describes as a subaltern internationalism that resists extraterritorial jurisdiction by imperial and capitalist forces, but also creating more avenues for civil society engagement from the global south, anchored in principles of self-determination and extraterritorial solidarity. To this end, I suggest that we already have a productive instantiation of internationalism in the jurisprudence on jus standi at the International Court of Justice. This jurisprudence on the procedural rights and responsibilities of legal personhood in an international court is not subaltern internationalism, but it is an internationalism that has the potential to open up political space for a more systemic critique of the dominant world order and for more subjugated perspectives to be rendered audible in the international public sphere. In a court of law, standing or locus standi can be understood as an adjunct to a claim to sovereign jurisdiction. Nation-state self-representation of their own interests in a case before the ICJ is a routine and uncontroversial performance of legal personhood. The legitimacy of states standing to represent interests that typically fall within the ambit of their territorial jurisdiction is a default assumption at the ICJ and can be seen as a key dimension of the rights and freedoms of sovereign jurisdiction over a territory. In contrast, claims of standing predicated on the solidaristic representation of self-determination interests of others, of peoples with no state of their own, has had a more contentious history. However, such claims to a transnationally grounded articulation of legal personhood are asserted more frequently, and in recent years, their legitimacy has become increasingly well established. The International Court of Justice has recognized that a sovereign that is not the injured party may still have an extraterritorial commitment to the injured, and the court's jurisprudence on standing has come to recognize this commitment as a legitimate erga omnes partes claim in such cases. Its most recent and spectacular expression was, of course, South Africa's representation of the Palestinians of Gaza with a genocide claim against the State of Israel. The spirit of internationalism represented in this chain of commitment was a crucial legacy of Bandung, and South Africa's articulation of the genocide claim was received in that spirit across the global South. The Bandung spirit inheres not in the decision of the court, whatever that may be, it may take some years, but in South Africa's initiation of the action, and most crucially in the sweeping support for South Africa's action across the global South by several states, thousands of civil society organizations, and if the marchers around the world are an indicator, tens of thousands of people. I would argue that the actions at The Hague should be seen as an echo of the popular protest slogan heard on streets across the world in solidarity with the people of Gaza. In our thousands, in our millions, we are all Palestinians. In elaborating on this expression of subaltern internationalism in international law, it is worth recounting some of the history of this form of extraterritorial solidarity in the context of the ICJ. While today the ICJ may offer one of the most hospitable forums for South-South solidarity, its record has not always been so salutary. In 1960, Liberia and Ethiopia exercised solidarity with the people of Namibia, then called German Southwest Africa, in instituting proceedings against South Africa at the ICJ for violating its mandatory responsibilities to the people of Southwest Africa. In a judgment that shocked the anti-colonial world, the court ruled that Liberia and Ethiopia had no legal interest in the matter at hand, and therefore no just standi to bring the case. The decision of the court was doubly problematic because the court not only perpetuated South Africa's denial of Namibian self-determination rights, in refusing to give legal recognition to extraterritorial solidarity as a basis for standing, the court also got it wrong on the question of internationalism, and in this way it curtailed Liberian and Ethiopian sovereign interests to the narrowly territorial. Indeed, Namibia's right to self-determination and Pan-African solidarity are inextricably bound in the question of Liberia and Ethiopia's jus standi. The language of extraterritorial solidarity does not emerge in the submissions of Liberia and Ethiopia, but it is a core concept that is articulated in their claims, in the opinions of the dissenting judges, and in the court's own jurisprudence in subsequent cases. This includes the recent submissions to the ICJ by Gambia regarding the threat of genocide against the Rohingya people, and by South Africa regarding the threat of genocide against the people of Gaza. In effect, Gambia and South Africa are arguing that these threats fall within their own sovereign interests. These submissions give expression to the notion that anti-colonial solidarity gives rise to a legitimate extraterritorial legal interest that can anchor standing, and the recognition of such interests is already sedimented into customary international law in the context of self-determination struggles. In a previous article in the American Journal of International Law, Professor Chimni has argued for a TWAIL approach to customary international law that draws on a more diverse range of sources. In this spirit, we can ground the legal status of the notion of solidarity in some 70 years of solidaristic engagement in a range of international fora to collaboratively advance the right to self-determination. We can also situate this argument in sources such as the General Assembly resolutions, the work of international institutions on treaty obligations and third-party interests, and resolutions of multilateral organizations such as the Non-Aligned Movement. These contribute to the notion that there is a legal right to solidarity in customary international law, and that this right emerged in ways that were co-constitutive with the right of self-determination. Fittingly, the Office of the High Commission for Human Rights, via its special procedures, is working on a draft declaration on the right to solidarity that explicitly recognizes that right in a human rights instrument. And in doing so, this declaration is not introducing a new legal principle, but is seeking to recognize a right that has already been given expression in the state practices of the formerly colonized world. As discussed, these state practices have given expression to jurisdictional interests that were extended through extraterritorial solidarities, especially solidarities with peoples whose right to self-determination continued to be denied. In the early parts of my paper, I spoke to the tensions between statist and non-statist approaches to transnational solidarity and self-determination rights. For restrictions of time, I did not recount that discussion here. But I want to say that this was a tension that traveled through the legacy of Bandung, but it's also a tension that travels through ICJ jurisprudence. And in a whole range of cases, including from the Southwest African case, you can see this in the dissenting judgments. For instance, Tanaka and other dissenting fellows in the wake of the Ethiopian and Liberian submission in reframing civilizational discourse of the mandate system as speaking to shared commitment to internationalist interests that are predicated on a commitment that the people of a territory will determine their own political destiny. They don't see this destiny only in statist terms, however. Rather, their submission situate in a very specific history of transnational activism against apartheid and the collective organizing against it in relation to both South Africa's internal rule within the country and its external role in Southwest Africa, then now Namibia. This is a history of social movements that sometimes enjoys the support of states and often in registered challenger states, including post-colonial and anti-colonial states. Today, there's a recognition that colonial laws, norms, and institutions are not in the past, but that these are part of our present, and challenging these inheritances entails rethinking territorial sovereignty as the name of freedom. Today, the protests against the occupation of Palestine and the genocide in Gaza have ignited a powerful left internationalist spirit whose contours of extraterritoriality challenge imperial and capitalist models of extraterritoriality as much as they challenge the territorial parochialism of the nation state. These are struggles for self-determination that have sustained by the spirit of extraterritorial solidarity, forged in contests as divergent as protests on city streets, classrooms and university squads, and of course the courtrooms of the International Court of Justice. Let me end there. Thank you.
Thank you so much, Vasuki. Thank you so much, all three of you. In our next segment, we will open up the presentations to questions from the panelists. And after you respond to some of them, we'll open up to questions from participants. For participants, we have access to the question and answer function, but the panelists, I think, can raise their hands and pose a question if they'd like to. And therefore, I open up the floor to the panelists. Does anybody have a question?
I'd like to ask Bhupinder how he would explain instances of India, like in the Bhopal case. And there's this case relating to Pfizer. Once India brought an action against Pfizer in the American courts relating to fixing of milk powder prices within India. So there are instances in India where India has had recourse to extraterritoriality of a foreign state. How does that fit into his picture of extraterritoriality? Sorry, have I? Is Bhupinder?
Thank you.
Yeah.
Thank you. With the permission of the chair, can I? Yeah. So my sense is that global South states are in a situation where they are sometimes left with no option but to actually turn to the oppressor for remedies. And I would suggest that it's not all dark out there. So there are gray areas. There are gray areas where powerful states need to legitimize the exercise of extraterritorial jurisdiction. And they may come up with categories, they may come up with the exercise of forms of jurisdiction that actually enable less powerful states to turn to them for seeking justice. And the key here is the legitimacy. Issue. I'm not overly familiar with that Pfizer case, so I won't be able to. But my sense is that each time the Global South turns, the fact that, or the civil society turns, whether it's the Vedanta case or other cases in relation to the exercise of universal civil jurisdiction, that's the only possibility that is available to many of them to seek justice. I mean, that's how I see it.
Thank you.
Yeah, we have another question. Shaman, do you want to go ahead?
Sure. Well, first of all, just thank you so much to everybody for joining us. And as a nominal co-host, I'll also just take a moment to thank all of those who have joined us online as well. My contribution to the symposium is on the question of universal jurisdiction. And so I was intrigued to hear that the definitional I won't call it a clash, but perhaps, a definitional difference of opinion on universal jurisdiction between our first two speakers. And it made me think that we may be seeing in the foreign investment context that Professor Sorna has written about extensively, and that we'll hear about in the second panel from Harshad Pathak, that international law in a way is a shield, right? That these bilateral investment treaties are essentially, as you said, insulating foreign companies from the effects of local law. And so in that sense, we've got international law perhaps as a shield. And in the universal jurisdiction context, I perceive international law to be much more of a sword for accountability. Now, to be sure, many studies have shown, and I think just anecdotally, that defendants from the Global South have disproportionately been sort of on the hook in universal jurisdiction proceedings in countries of the Global North. And so certainly universal jurisdiction is not a panacea. But are there principles that we might elaborate that would help us determine when exercises of universal jurisdiction, that is the application of international law in the domestic courts of a third state, rather than an international forum that Professor Nesiah talked about, when those might be viewed as salutary from a TWAIL perspective, and when those might be viewed as disfavored. And I will say that American Society of International Law panel that Bharat Arjun mentioned, we had Obiora Okafor as an intervener, and he proposed an idea of a colonial impact assessment, perhaps, for exercises of universal jurisdiction. So if any of that prompts further thoughts or commentary from the panelists, I would welcome it.
If I may respond to that,
Yes,
I
please.
think universal jurisdiction, to a large extent, does not cause anxiety to developing countries or or generally. The acceptance of genocide as an international crime is an example of universal jurisdiction. The very fact that there's general acceptance makes it fall outside extraterritoriality. Extraterritoriality having an obnoxious aim behind it. Like, for example, when the United States imposes export controls on China or on Cuba, there is a sort of an unwilling person involved, Cuba, and other persons who want to trade with Cuba are affected by it. Like, say, you bring an action against Petronas in Malaysia because they trade with Cuba, then you're affecting a third state which has an interest in this trade. So in the case of genocide, such consequences do not flow. There is no hostility involved in it. There's general acceptance that genocide should be a crime. So too in the case of slavery and piracy, I mean, assuming there are no economic reasons for the abolition of slavery and piracy, you would think that there was universal acceptance that these incidents should be regarded as criminal. So one would think that there is a sort of a common interest. And one would also think in future relating to climate change, if there are legislation or enforcement of such legislation relating to climate change, that will be welcomed by other states because it's in the common interest that this be done. Extraterritoriality, to a large extent, lacks that common interest, except in certain situations which I call defensive extraterritoriality, where the form is there, but in substance, it has a common interest, like controlling money laundering or international fraud. That's my view on this.
Professor Chimni, Vasuki, did either of you want to respond to the question?
I have nothing. Professor Chimney is probably the best person to.
Please go ahead, Vasuki. I'm still thinking about it. So if you have a response.
No, I wasn't. I didn't have any strong response except to say that often, what there is consensus about, it may be an indicator of where there is of the issue that is not, in fact, the most controversial issue. So, as Professor Sornarajah says, there may be wide consensus that genocide has to be condemned. But then, again, to invoke Jacques Derrida, who Professor Chimney invoked earlier, then it may suggest that the real question is not about whether genocide is to be condemned, but where there is genocide or when we see it, or the materiality of genocide in a particular context. So it's not exactly responding to the question, but it was merely a little adjunct to the question about how we in a sense, I perhaps to link it back to the earlier discussion when Professor Jindal spoke about the question of crisis in relation to the logic of capital and the question of the logic of territory. For one way in which we may think about, where to intervene in international law and where the stakes are the highest is precisely by following the crisis in some sense. So if there is consensus on something, it may well mean that may not be the most politically potent or the most important issue on which TWAILers may need to intervene, and the intervention may be precisely in something that is therefore an adjunct.
Can I also add that enforcement is different from the existence of law, like say genocide. I mean, there is a concern about genocide in Palestine, but I, as Tamil from Jaffna, would say that there was no similar concern with what we think as genocide in Jaffna, during the civil war there, when large numbers of civilians were killed. So the response is not the same, though. But, there is nevertheless the fact that there is consensus behind certain crimes like slavery, genocide, piracy, and other war crimes. But when it comes to enforcement, we know that Blair and Bush, for example, are not prosecuted, but many African leaders are brought before the International Court. So enforcement and the law, of course, there is a gap there that has to be noticed. Yeah.
I have nothing to add. No, I have nothing to add to this. Sorry, I interrupted someone. Yeah.
Oh, no, no. I was just saying we have some questions from participants, and I was going to abuse my position as moderator and throw in one question before we jump to participants. But Professor Chimni, did you want to respond to any of this?
Where is what's the question? Is it in the chat box? Yeah.
We'll read them out to you. There are two. We are waiting for participants to share more questions, and then we will be sharing them with the panelists.
Okay. Okay. So
I had a question in the meantime, if that's okay.
Please go ahead, Rohini, please.
I actually wanted to continue with what Professor Sona was saying and bring it back to something in Vasuki's article, which is we've also seen a difference in international solidarity or extraterritoriality when it comes to these sort of definitions about what kind of matters should be taken, regardless of the existence of law, where the law applies and where it doesn't. So in that vein, I wanted to ask a very serious question of how can we think about non-statist solidarity, non-statist transnational solidarity in times of ethno-fascist states, in times of hegemonic states. If those are the kind of solidarities we are envisioning, and we have to think of law more horizontally in that instance, what are some effective ways of making this happen? What are the modalities? What are the techniques? Where do we begin this conversation? To any of you, if you want to respond.
I would request Professor Nesiah, because she I spoke eloquently about this question, and I agree entirely with every word that she said. So can I request her to respond to this question? Please.
Yeah, I mean, I think Professor Chimni would be much better position, but Rohini, so you were asking about where would we start with thinking about transnational solidarity in this context? I mean, I think this current moment is surely one of them. And as Professor Sornarajah said, there are many atrocities in the past in many places, certainly in Sri Lanka, but also in Iraq, in Afghanistan, across the world, where the international law has been silent, and where even efforts to bring, and including in Israel, where efforts to bring in cases in the past, like the wall case, even when the case was successful, it has proved largely irrelevant in terms of actually catalyzing the kind of discussion we're having today. So while today it seems that the International Court of Justice is both an opening and a risk in terms of that kind of international solidarity. It is an opening in terms of the what we have seen with the South Africa case, where it has opened up a space for thinking about what is the accountability that international law has to the people, as opposed to sort of a downward accountability, as it were. On the other hand, it can also, law often, whenever, especially victories in law, can often seduce us into believing that law is the name of our victory. And so there is also the question of it's really not the International Court of Justice, has both been irrelevant to this, even the provisional measures have been irrelevant to what Israel has done. And of course, it's not going to, in some sense, penetrate what Professor Chimni describes as the logic of capital and the logic of territory. That this is just one battle in a longer process, and the fight needs to continue. And the courtroom may not be the only forum on which we continue that struggle. So that so I think those are good reminders. The discussion of the reach of capital and the reach of empire are good reminders that the struggle has much larger contours than the four walls of a courtroom.
Thank you so much, Vasuki. Professor Chimni, Professor Sorna, would you like to respond?
No, that's fine.
So we shall move on to some participant questions that we have. We have about 5 of them. Let me just see which ones we can club together. which ones are most pertinent to our session at the moment. We'll start with a question from Harsh Manohar, who asks, my question is regarding the international capitalist class, which is growing increasingly delocalized, especially with the growth of ISDS. How does this delocalization interact with the logic of capital and logic of territory?
So, my response to that would be that it's not very easy to answer that question. There is a complex map of interface between the two logics here. It's difficult to difficult to predict how each individual state would react to the rise of what I call the transnational capitalist class. In nations where the local capitalist classes are not integrated with the global capital processes, there will be moves to opt out. So we have seen countries who opt out of the ISDS system. Honduras, if I'm not wrong, was recently exited from. So what I want to suggest is any form of generalization here. But yes, with the key states, with the key emerging powers, where the fractions of the nationalist capitalist class which have a stake in the global capital processes are so well integrated into that circuit, they would be willing to stay with the ISDS. They would be willing to stay with even the ISDS system, and you can see reflections of that in the BRICS in the BRICS nations. So again, I don't want to give a response which doesn't sort of capture, but I want to ask a question in turn in response to the previous one, and this is to Professor Sornarajah. So he said we shouldn't keep working with the category of imperialism. So how would you describe the support of the continuous support of the United States to Israel at this moment? Even as it seems to try and draw it back. What is the category that you would use which would allow us, we could offer a realistic explanation. We could go back to Morgenthau and perhaps make an argument. But what other category would you adopt in order to explain the US's support in terms of arms, resources, and of course vocal diplomacy? How do we sort of how do we capture that?
Well, my short answer, Bhupinder, is that this falls outside the topic that we are discussing, extraterritoriality. But let me give you attempt an answer. I would say that the United States as a hegemonic power finds its interests best protected by Israel in the Middle East, right? So it has a proxy to ensure its hegemonic control of the region, right? And its intent on ensuring that that proxy is maintained through the use of its own power. Now, coming back to the question relating to ISDS, I must say that ISDS is going to be there for a long time, despite Honduras, despite even the Americans pulling back now because there was a long list of American academics suggesting that ISDS should be dropped from investment treaties. But as Bhupinder says, I mean, the hegemonic power employs different mechanisms. One of them, in the case of Israel, which he mentioned, is evident desire on the part of the United States to use Israel as a proxy that would remain an agent that would remain in order to keep that region in control and also the resources of that region. Again, we see that diplomacy focuses on the existence of resources and the keeping of those resources. When we think in terms of the creation of ISDS itself, many of the early cases relating to ISDS in the 1950s in particular, the Abu Dhabi arbitration, the Aramco arbitration, all involved the Middle East, and again, having Israel there is vital to the pursuit of foreign policy by the United States. You might call that an instance of extraterritoriality through the employment of the agency of Israel. But coming back to ISDS, you don't have to go as far as Honduras or some of the smaller Latin American states. The Indian example itself indicates that investment treaties continue to be made despite some effort to terminate treaties. There's a remaking of treaties. There are some 28 arbitrations currently against India. There's no desire at all to give up ISDS. So what happens is that the elite in India, and you can see this in the Law Reform Commission's efforts in respect of formulating the newer version of the Indian Model Treaty. The retention of ISDS is very much a feature of that effort, though it was a commission that was led by the Chief Justice Chandrachud. They came out with a recommendation that ISDS should be retained. So there's no effort at all to dismantle ISDS, despite the fact that India has a string of cases to face at the moment and suffers disadvantage as a result of some of these cases. Indian diplomatic premises being seized abroad in France, efforts being made to seize even Air India flights in certain jurisdictions in order to recover, to enforce awards that have been made. So you do see that there's an epistemic community of arbitrators, of lawyers who are resistant to the idea that developing countries give up ISDS. And some of this community, of course, resides in countries like India. The top lawyers and judges in India benefit a lot by ISDS, and they're resistant to the idea that they should give it up. So the transnational elite class, which is becoming smaller and smaller and more powerful, is also reflected in countries like India with the Indian capitalist classes, which are also small, imposing a lot of power and effort into the preservation of an international law that is pliant to the service of their interests. Right, let me stop there.
Thank you so much. That was a very, very rich discussion. We will have to take a break now for our following panel so that our speakers and our audience is refreshed. We've made notes of some emergent themes, which we'll hopefully be able to discuss in tomorrow's open session, some around the use of extraterritoriality against neocolonialism, some around the ideas of continued hegemony through some of these institutions. We'll pick them up again tomorrow. For now, thank you so much, panelists. That was a wonderful discussion. So many questions unanswered on account of paucity of time. My apologies to everyone whose questions we couldn't take up. And we will see all of you shortly after the break. Thank you.
Thank you. Thank you so much.
Thank you.
So I think we will reconvene in about 2 minutes. And we'll have a panel with 4 of our contributors. All right, well, I am Chimni Keitner from the University of California, Davis School of Law. As mentioned earlier, we are convening across multiple time zones. So thank you so much to all of you for making time in your busy days to join us. We are also recording the proceedings. And so if you missed any of this morning's discussion, we will certainly be posting that both for the California International Law Center here at UC Davis and also, of course, the National Law School of India Review, which has convened this entire wonderful symposium. So we have 4 very interesting contributions to the symposium to discuss in this next panel. As we did last time, we'll just go in the order of the program and offer about 10 minutes, which of course is insufficient to each contributor to sort of summarize their contributions, which will again be available in due course in print in the special issue of the National Law School of India Review. And then after those initial interventions, I'll be delighted to take questions both from other contributors, and we will get to as many questions as we can from the Q&A panel, understanding that, as Professor Sen mentioned before the break, we also have a bit of time for open discussion in tomorrow's follow-on session. So we're certainly also taking note of those questions in the Q&A panel, and we'll carry over as many of those as we can to the open discussion tomorrow. So without further ado, and maybe I'll have you just mention your own institutional affiliations when we turn to you. We've got a fascinating paper continuing our discussion before the break of investor-state dispute settlement too. So over to you, Harshad.
Thank you so much, Professor Keitner, and everyone else involved in organizing this wonderful discussion. Like so many others, I can only highlight the importance of having these discussions which break the boundaries of traditional discourse in a safe space. And I think this roundtable and the special edition that will come out is a good example of that. With the pleasantries out of the way, I think I'll briefly summarize what my paper is broadly about. It takes inspiration from what Professor Chimni described earlier today as one of the challenges increasingly faced by TWAIL scholars about having done such excellent theorization and unraveled the relationship between the doctrine, the politics of the law, and the role history plays into it. There is an increasing challenge about what do we do with it, and can we use it to engage with purely legal or doctrinal issues in a more effective manner? I think with this paper, I try to answer that question affirmatively, and I look at the framework of investor-state dispute settlement through arbitration as an example. The case study that I opt for is a decision on jurisdiction in the case of Cambodia Power versus Kingdom of Cambodia. It's an ICSID decision where the tribunal had derived its jurisdiction, briefly put, from 3 related investor-state contracts. So it wasn't a treaty case, but all 3 agreements had a compatible ICSID arbitration clause, and all 3 of them explicitly provided that these agreements would be governed by English law or the laws of England, as the case may be. The investor in an ICSID arbitration pursuant to these 3 agreements essentially also put forth claims based not on English law, but alleging that there's a breach of certain customary international law minimum standard of treatment obligations that Cambodia was also bound by. Cambodia objected to the jurisdiction of the tribunal, saying that the tribunal jurisdiction is confined under that contract to deciding claims that involve English law and not MST. The tribunal's decision, tribunal rejected Cambodia's objection. It affirmed its jurisdiction to decide the customary international law claims, but it's the reasoning where it gets very interesting. In saying that they had jurisdiction, the tribunal essentially said that customary international law and the minimum standard of treatment is fundamental or inherent when it comes to issues of protection of foreign investment. And therefore, it considered it simply unrealistic that the parties, by designating a national law, in this case, English law as the law governing the contracts, would have intended to exclude a customary international law jurisdiction as far as investment of protection of foreign investment is concerned. It is this decision, and particularly the reasoning, that I tried to critique using the lens of third world approaches to international law. But before looking at why the Cambodia Power Tribunal's decision and the reasoning is vulnerable to criticism, there is a need to problematize the notion of jurisdiction. And I understand the jurisdiction here as the subject matter or ratio materia adjudicatory jurisdiction of an international law tribunal, in this case, an ICSID tribunal. And unlike conventional notions, this is not a purely legal, but it's inherently a political notion. Jurisdiction, as so many scholars have theorized, it's a mechanism through which exercises of authority are legitimized as law, meaning that determining the scope of an international forum's jurisdiction means to decipher the extent of the tribunal's authority over states. And it's not without consequences. The more expansive is the subject matter jurisdiction exercised by a community of adjudicators, let's say ISDS arbitrators, the greater is the ability of the underlying interests, values, and expectations of that community to shape legal norms that directly impact state behavior, how states act, not just in terms of protecting foreign investment, but also taking into account whether the policy decisions that the states may want to take in public interest can have an increased cost on account of ISDS. So this has to be the starting point, that the notion of subject matter jurisdiction of an investment tribunal is not a legal discussion. Politics is intertwined in it. From this lens, I think, given the time constraints, I'd point out two reasons that I discuss in the paper why Cambodia Power Tribunal's ruling and the reasoning is wrong. Firstly, there is a fundamental difference between the binding nature of a supposed customary international law norm and a state's authorization to an arbitration tribunal to decide claims alleging a breach of CIL norms. Unlike municipal law, in international law, and again in ISDS as well, there is no ubi cessimi remedium. It is commonplace to have binding substantive standards, but not provide an adjudicatory forum with the competence or the authority to decide disputes whether such norms have been breached or not. The concept of jurisdiction relates to the authority given by a state to certain individuals, to a body, to not just consider whether certain norms are binding or not, but whether an alleged breach of such norms is something that they can decide. Do they have the authority to apply? And these two distinct notions were conflated by the Cambodia Power Tribunal. And that is already, you can see, a doctrinal flaw. The second vulnerability, I think it's more obvious from a TWAIL perspective, is the assumptions made by the tribunal about the inevitability or the omnipresence of customary international law when it comes to the protection of foreign investment. Now, the colonial underpinnings and the political dimensions of customary international law and the context in which ISDS or investment treaties or investment contracts themselves became popular is something that the tribunal ignores. The tribunal's rationale that it's unrealistic that a state which is party to an investment contract would want to exclude customary international law norms does not withstand a historical scrutiny. Far better people have written a lot about the origins of customary international law as a concept, as well as investment treaties and the intrinsic link they share with the colonial encounter. We have Professor Chimni and Professor Sornarajah, whose literature informs us. These are not new things, but it's for us and it's for tribunal members to take notice of and not ignore while making assumptions that directly affect the outcomes that they reach. Both CIL and international investment law norms are developed in the immediate context of colonial hierarchies, and these hierarchies continue to exist today, even if they're evolving. The conversation may shift from a former colony or a former colonizer to a more or less powerful state. India, as Professor Sornarajah pointed out, is a wonderful example to look at a former colony whose identity is now gradually evolving. And so is its either affinity towards or its resistance to investment treaties. But knowing this history shows us that it is not unrealistic for Global South states to exclude CIL norms. In fact, that is more likely to be their intention. And if these corrections were to be made, and I think TWAIL as an approach allows one to see that, then It provides ample grounds to see why the Cambodia power decision's outcome actually should have been or could very well have been the opposite. So that's where I'll stop, and then we can take the discussion forward with questions.
Thank you so much. And again, I think, picking up from the previous panel, this idea of the role of customary international law and its uses in both sort of defensive and offensive ways, it is a fascinating theme that percolates through and across some of these subject matters. So we'll certainly return to that in the discussion. We next have Eric Loflad, who will talk to us about a region of the world that is sometimes overlooked in these discussions, but that has much to teach us. So over to you.
Nice hangover from the COVID times. But anyways, thank you all for being here, and a very special thanks to the organizers for putting together this really incredible event and opportunity to have these super important conversations. And what I want to talk about, and going on this whole theme of this region of the world that, maybe we could focus on in this specific way, I want to center Latin America as really being the origin of this quote unquote third world statehood before the third world really became the explicitly framed project it did during decolonization. And in doing this, I take 2 points, from Professor Chimni's article, one being more substantive, this whole notion of, when we talk about jurisdiction, and there's often this default focus on extraterritorial jurisdiction, there's that whole normalization of, what about that jurisdiction within a nation state? Something that, at least at the international legal level, is typically seen as uncontroversial because that's a matter of the state's domestic sovereignty, and to judge that then really raises these questions about sovereign equality or non-intervention. But then where did that very normalized presumption of domestic jurisdiction come from, especially as it related to this idea of that bounded nation-state form, in particular when so many of the original states in the international system were these expansionist imperial states? And the second point, more methodological, that I think really does feed into this is that idea of, how is it we do get beyond these doctrinal abstractions that are abstracted in certain ways to the advantage of certain individuals over others, and how do we expose these underlying social conditions, and to what extent do we look at that on this long time scale? And here, I'm really influenced, and this was what my PhD thesis basically was, how do we bring in this notion of historical sociology to retell that story, especially in allowing us to look at these matters of domestic jurisdiction and the foundations of it as it evolved in this broader international, transnational, imperial, inter-imperial context. And towards that end, I really focused on Latin America and the extent to which that raises this question of, what were the social relations, both existing there before the European encounters, but then what were the social relations within Europe in this time frame of pre or proto-capitalism, and how is it that interaction created this set of social relations that, yes, they'd had to adapt to changes in the world, but really by their nature were pre-capitalist, and that is the model for, that colonial domination. And there I look at Latin America in a way that really draws heavily on scholars such as Alexander Nievas and Karim Nasanjialou's How the West Came to Rule, the Geopolitical Origins of Capitalism. And there they talk about how with Latin America, you have to consider the class conflicts that were happening in continental Europe, between the nobility and centralized monarchies, and how there would be huge issues if these colonizers, these conquistadors, were able to claim these feudal lordships in the Western Hemisphere. So it was this notion that, okay, sovereignty is now this abstraction, just based on this claim to land. So there can't be that same type of feudal personalized sovereignty. But then there was the huge retooling and intensification of much of the whole tributary system that existed in the Andean and Mesoamerican empires. And how is it that that then synthesized with this European feudalism created a set of social relations that then really shaped the basis for, well, what was the entity that was to emerge when these societies gained independence or revolted for independence in the early 19th century. And how does that then have to be considered in relation to the pressures that were being exerted, well, from Europe, whether it was the reactionary dynastic powers after Napoleon, or from capitalist entities such as the United Kingdom. Also, what's the role of the United States here? This is the time of the famously proclaimed Monroe Doctrine. And how is all of this informing this particular notion of international law as it's happening, that is creating this logic of statehood and this logic of territory that is not designed explicitly to facilitate these expansionist forms. And of course, yes, there was plenty of expansionism happening within these bounded social spheres, especially as it related to suppression of indigenous communities and various other subordinated populations, including the large slave populations that existed there until, at least in Brazil, until the end of the 19th century. So how is it that looking at that really does give us this view of international law, especially in this really pivotal moment when there is this shift happening from dynastic sovereignty to this notion of popular will as the basis of sovereign legitimacy, as was famously demonstrated. So American Revolution, revolt against the British Crown, French Revolution, destruction of the pre-existing monarchic order there. But then how is it in going beyond these more famous examples, we look at, well, what was happening in Latin America? What was the formation of it? How did these inherited social structures that were these this particular synthesis of indigenous social practices and European feudalism become these sovereign entities, and how did the emergence of these sovereign entities that didn't have similar opportunities for expansion really shape and change our notion of what is international law, and how is it that that is so much of the frame for so many, well, for one, contributions from the region. How does this help explain why it is in these parts of the world that we really do have these very robust notions of sovereign equality and non-intervention? And yes, these concepts did exist earlier, but they were really, really refined in the Latin American context. And I know I talked about many things here, but just to wrap it up a bit with a certain point that says something about this particular, just how this changed the doctrine, especially if we get to non-intervention, sovereign equality, and that presumption of the unquestionability of localized jurisdiction within this sovereign sphere, whose particular form of government couldn't be judged externally. In the very famous international legal treatise, the text, The Law of Nations by the Swiss jurist Emeritus, that's very famous for introducing these notions of non-intervention, of sovereign equality, famous line being, a dwarf is just as much a man as a giant, a small republic is just as much a nation as a great empire. Despite all these proclamations, one of the things that he mentions as a possible exception to this otherwise ban on the usage of force against sovereign equality or to legitimize this intervention was preserving the balance of power. So here we have this notion very much tied to this European dynastic diplomacy. And it was Latin American jurists, particularly Andres Bello, who really took that point to task and said, no, that just can never be a justification for intervention. Who gets to name what the balance of power is? How is it they could take that particular license with it? And how is it that that has to be rejected if there's going to be any hope for entities like this surviving within this system of various forms of predatory expansion, often by the logic of capital, which then gets followed by the logic of military force? And how does non-intervention and that very, very basic, blunt definition of jurisdiction become maybe a necessary, if not sufficient, condition for achieving that? So thank you.
Thank you so much for that, and for bringing sort of the experience of that part of the world into the conversation, and for giving us themes that we can certainly explore in discussion, including something that you mentioned in the paper about the criteria of the Montevideo Convention and how we even think about the idea of a nation state. So without further ado, let's turn to our third presenter, who I think is also going to share his screen and tell us about a fourth world approach to international law and some of the groups that may be overlooked with our sort of exclusive focus on the nation state.
Thank you. Am I audible? So I will be sharing my screen. So I hope it is visible to everyone.
We can see your screen, and you can just come a little closer, speak a little louder. That would be wonderful. Thank you so much.
Thank you. So first of all, I would like to thank the organizers and everyone present here. And I would also like to tell that it is my absolute honor to be speaking before such a esteemed panel and before Professor Chimni, because the international law is not something which has interested me in my law school, in my LLB, but in my LLM, I had read about the fourth world, and then and there only that I have written this paper. So basically, my paper is about that what is the fourth world approach and whether it is a challenge to the third world approach or it is an extension to it, right? So the basic premise of the fourth world is that it is a socio-political path of the indigenous rights, right? So the basic subjects of the fourth world is on the indigenous people, and it is basically focusing on the us of the international law and the others of the international law. So when we are saying that this whole discussion about jurisdiction that we are talking about, so we are assuming that the states have a certain jurisdiction in which they are exerting or they are utilizing their power, or they are making laws for them, or they are recognizing their rights, they are giving them rights and the duties as well. So this is a basic premise in which we are saying that the states are doing something, right? So then there comes the discussion about that what about the things which are not in the state or which do not want to be under the broad category of state. So the basic premise which the fourth world approach talks about is the others of the international law, which are not being recognized at the international level. Because when we are talking about the international law at present, it is generally focusing on the first world, second world, and very recently the third world as well. But the certain individuals or certain communities. For example, Professor Chimni has also talked in his speech that there are certain people, for example, the caste, the class, or there are certain things which might be included, which might be added in that third world approach. So they are these I am terming as the others of the international law. So we have to get to them as well, right? So when we are saying that we are talking about the states and their jurisdiction, then if we look at the Westphalian approach towards the nation state, so they assumes that nation and states are one and the similar things and they are congruent, right? But when we talk about the fourth world, it talks that no, this nation is a different thing, which wherein we talked about the voices of indigenous who are being neglected or who are being ignored, right? So nations can be present anywhere. It can be present in the first world as well. It can be present in the third world as well. So as Professor Sorna has highlighted that there are the new oppressors in the third world as well. So when the third world is oppressing these people, so who will come to their rescue? That's where the fourth world comes in the picture. That the fourth world is to take care of the exploitation or the rights of these indigenous people or these neglected classes. So basically, it is the when we talked about the TWAIL, it is focusing on the subjugation based on colonial encounters only, wherein they are focusing broadly on the north and south dichotomy. And they are treating the third world as a homogeneous group, which do not have different categories. But when we talk about the fourth world, it talks that there are certain ignored species or ignored groups in the third world as well, or in the first world, in the second world as well, which the third world is not talking about. And this means that they are talking about the marginalization of the marginalized, right? So they are saying that when we talked about the third world, so this is not a homogeneous group only. There are various heterogeneous groups in the third world, in the first world, in the second world. In all the world, there are various heterogeneous groups which we have to take care of when we are talking about the framework of the international law, right? So I have given one analogy of the frame of reference while talking about these different worlds. So if we take this is one train, there are two trains with same velocity, which is v. So international law is the first train and the first and second world are the second train, right? So if we look at the international law from the perspective of first and second world, so because they are having this similar velocity, so we will see them that they are static, right? And if we take this as a plane of rights, so we can see that there is no violation of rights. But if we change the frame of reference from the first and second world to the third world, that is the C1, and here the C1 is having a velocity which is lesser than V, right? So here we can see, because the change of frame of reference, we can see that there is a change in velocity and hence there is a greater violation of rights. But if we come to the C2, that is the last car, then it is having velocity which is even lower, or which is lower than V1, right? So it is moving towards the international law, or if we look at the international law from the frame of reference of C2, then we can see that there is a greater violation of rights. So it means that Foucault in one of his articles also said that we have to change the prism, we have to change the location from where we are viewing the rights or we are viewing the duties, because the privileged won't see that there is a violation of rights. The exploited person or the person who are at the lower pedestal will see that there is a violation of rights, and we can only see their violation, or we can see their exploitation if we change our frame of reference to their frame of reference. And this is why we are saying that we need to put ourselves in their shoes, or if we cannot put ourselves in their shoes, one major thing is that we have to frame or we have to accumulate them, we have to accommodate them, we have to invite them to these discussions so that they can put forward their views, so that they can be assimilated in the international law framework. This is what my article is talking about, in which I have given 2 examples as well, that how it can be helpful to accumulate or to accommodate them. And that's it from my side. Thank you.
Thank you so much. And I think, you know, if Eric's paper brought another sort of geographic area of the world and historical experience into view, you've really shown us that there are perspectives within existing nation states that may be erased or overlooked. I think there's I'm going to show my ignorance here, but the expression that, you know, there is no view from nowhere, right? And so thank you for reminding us of the importance of our own positionality in approaching these questions. And so finally, but certainly not least, we'd love to turn to Professor Kaliki Mehta to talk about another aspect of legal personhood. Professor Nesiah this morning talked about legal personhood, and we've just heard about another form of legal personhood. So she will talk to us about corporations and the environment, which is also something that Professor Sorna alluded to when he mentioned climate change as a common interest. And so we're very much looking forward to your remarks.
Thank you. Thank you, Chimni, and to Rohini, not just for this, but also for including my contribution in this symposium and the opportunity to be a part of the discourse that's driven by Professor Chimni's paper, which is an honor, and also to the NLSIR editorial team for the entire process so far, which has been a pleasure. But as was mentioned already, the thematic focus of my contribution is international criminal law, a subdiscipline of public international law that seeks to establish individual criminal responsibility for large-scale violence, such as genocide, war crimes, crimes against humanity, etc. So the paper aims to achieve 2 goals mainly. One is it's illustrative, and the second is exploratory, both in direct reference to the arguments made by Professor Chimni in his paper. It looks at extraterritoriality in international criminal law in the context of extraterritorial prosecutions and corporate complicity in international crimes, where the focus is on how such extraterritorial jurisdiction, principle of extraterritorial jurisdiction is implemented, which is selectively by advanced capitalist states. And secondly, in the context of environmental harm and the crime of ecocide, where the principle of extraterritoriality is being invoked to address a problem that disproportionately affects the people of the global south or the third world. So as it came up also in the first panel, the system of international criminal justice establishes universal jurisdiction for core international crimes that gives the state the power to punish an offender even in the absence of a clear link to the state. That is irrespective of where she perpetrated her offense and of both her nationality and that of the victim. So in practice, this principle is increasingly being invoked by advanced capitalist states to conduct what are called extraterritorial prosecutions against perpetrators of international crimes before domestic courts. So the underlying justification to such exception is that the nature of crimes is such that they affect and concern the international community as a whole. And I mark it in quotes because that's something that's highly controversial. And that any state that should be able to punish them, regardless of where they were committed, by who and against whom. So these crimes that shock the conscience of the humanity, suggesting an ostensibly universal value system here, making those who commit those crimes the enemies of humanity instead of just enemies of a particular state. So the state exercising extraterritorial jurisdiction in these cases is acting on behalf of the international community, neatly wrapping up these prosecutions in a liberal internationalist vocabulary and framework. So while the goals of such exercise are noble, it is important to note that when it comes to implementation of this framework, it is almost entirely being implemented the advanced capitalist states, using Professor Chimni's terminology here. And these are the nation states which have historically perpetrated unacknowledged and unaddressed large-scale violence against the peoples of the Third World and are now in charge of implementing international law, and in the process also shaping the norms of its further implementation, all in the name of global peace and security. So the practice of this exception also supports Professor Chimni's claim further that treatment of the principle of jurisdiction is ahistoric and intertwined with the logic of capital, because it is most evident in how the corporations, the multinational corporations, which are often headquartered in such capitalist states, have been enjoying impunity for their complicity in crimes often committed in the so-called global south or the third world. This disparity is also very obvious in the unequal treatment between the so-called other, the racialized, the marginalized, the political pariah on the one hand, and the coveted in need for protection and legitimation, the multinational corporation on the other hand. So it is often in the interest of the domestic and foreign policy of these third states who are exercising extraterritorial jurisdiction to target almost always mid-ranking, politically inexpensive perpetrators from the third world while acting as agents of the international community, but at the same time holding corporate conduct under tight scrutiny or similar level of scrutiny would be counterintuitive to creating conducive conditions for universalizing capital. Now, with that, I'll move on to the second leg of my contribution, that is the environmental harm, and particularly coming to climate change and ecocide. So as a response to such ahistoric and selective use of the principle of jurisdiction, the proposal, one could argue, of subaltern internationalism that's been made by Professor Chimni as a more democratic and historically informed model of reform offers an alternative to liberal internationalism that centers the interest of global South states and groups. And that appears to be a logical continuation of TWAIL's central concerns and the underlying aim of critiquing the legal framework with an eye towards more just reconstruction. And the preliminary structure of this reform model of subaltern internationalism offers a great starting point to analyze the problem and the solution that I'm going to discuss here. And this proposal of ecocide to address environmental harm uses international criminal law, which as I established was just in one context biased, but it generally is considered to be very biased and selective in the way it's implemented, and using that to address a problem that disproportionately affects Global South. So the ICC statute currently recognizes, the International Criminal Court statute currently recognizes 4 core crimes. That's genocide, crimes against humanity, war crimes, and crime of aggression. So there are many kinds of violence that fall through the cracks of these definitions. And one such shortcoming is the violence against the environment. And there have been dedicated efforts by various individuals, organizations, civil society, legal experts to propose ecocide as the 5th core crime, for which individuals could be potentially held responsible for wanton environmental destruction. Now, this proposal has been lauded and challenged on many different counts, and lauded particularly for being a civil society attempt, a non-statist attempt at lawmaking, which is usually considered an exclusive prerogative of the states, and giving voice to the most directly affected. But there are 2 aspects of this proposal that I discuss in my contribution, which are relevant to this symposium more broadly. That one, how this concept poses a challenge to the mainstream understanding of the principle of jurisdiction, and 2, whether it would be ineffective, if not actively worsen the existing divides, if international criminal law was used to respond to subaltern problems without addressing the pre-existing biases of the system, for instance, in this case, corporate complicity. So if international criminal trials are used to punish those responsible for ecocide, that would undermine the use of exclusive territorial jurisdiction of states over its natural resources in order to center the interest of weaker states and their peoples. For instance, such criminalization would acknowledge how a state regulates or fails to regulate conduct, impacting the environment and natural resources within its territorial boundaries, and makes the matter an international concern. So this proposal of ecocide therefore sort of sits somewhere uncomfortably between the principle of jurisdiction and the logic of capital Professor Chimni was talking about earlier. But at the same time, it also does not neatly fit into the typical exception of this principle of extraterritoriality, because those seeking responsibility for such harm are not just acting as agents of international community. It challenges the predominant territorial frame in which jurisdiction operates, and not just peripherally or procedurally, like the principle of universal jurisdiction, but substantially, as it questions the fundamental connection between the state's authority over its territory. But on the I'll move on to, I notice I'm nearing my time, so I'll try to wrap up. But on the question of using international criminal law framework as a response to environmental harm, my contribution highlights that unless international criminal law sheds its obsession over individual responsibility, it's hard to imagine any meaningful employment of this legal framework to address the global problem of environmental harm. But that's not to say, or that's not to undermine the symbolic and the communicative elements that serve a great deal in mobilizing sort of symbolic message or communicative elements of such proposal that serve a great deal in mobilizing civil society and furthering transnational solidarity. And in absence of other avenues, and as was highlighted already in the first panel, proposals like these can become a channel for the third world peoples to take targeted action against hegemonic powers. And for in this instance, it would be multinational corporations and sort of seeking reparations directly for environmental destruction and climate change. I'll stop there and look forward to the discussion. Thank you so much.
Well, thank you, and to all of our panelists. I'm sure the public attendees are all having their appetites whet to read your full published contributions. And I think also that last presentation not only drew together a number of the themes from the morning, but one of the themes that has been coming up also in the first panel is the substance of the laws, and then the form or the mechanisms through which they are either enforced or not enforced or selectively enforced. And I think you really make us think twice about the ecocide proposals, which do seem very compelling, but shouldn't be adopted uncritically for all of the reasons that you elaborate. So as we did the last time, I would welcome other panelists and or contributors if you have questions you'd like to pose or observations to make. And then I see we're already getting some questions in the Q&A, and I welcome members of the public audience to please continue contributing questions in the Q&A as well. And we will turn to as many of them as we can. But we're going to start off with a question from one of the fathers, may I say, of this project, Bharat Arjun.
Thank you, Professor Keetner. I was particularly interested in Professor Kalika Mehta's presentation. I thought it actually deals with a lot of things that we are here to discuss, especially like Professor Keetner mentioned, the substance of a law and how it's enforced. So in terms of this, I think one thing I find particularly interesting is if you think a little beyond jurisdiction and broaden the framework a bit, something like the responsibility to protect, where it's something that you see codified in international human rights instruments and other such things. And the exact nature of this is disputed, but I thought that it interweaves well with a lot of things Professor Kalika Mehta has said. And in common discourse, there's obviously this critique that it's open to capture by hegemonic forces. It's often used to amass financial, political, or otherwise capital. But there's also, I think there's also another side to it where people genuinely endorse it as a meaningful way to protect against atrocious crimes or anything of that sort. So if we go by your framework of thinking, Professor Mehta, perhaps could clarify on something like that as well. How would you think of the responsibility to protect in that context? Do you think of it as tied to jurisdiction? Do you think of it as separate? And then how can we think about the exercise of it in more equitable or honest fashions? I'm curious about that.
Should I take that already?
I think
okay.
we have time to sort of engage in an actual dialogue. Yes.
Great, thank you. Thank you, Bharat, for asking that question. It's sort of, I feel like having sort of chosen international criminal law as my field of engagement and coming with sort of TWAIL or aligning with the TWAIL value system, I deal with this almost every day, this duality and this sort of complexity that look at the driving principles, you look at the values, you look at the aspiration that that these principles hold, and responsibility to protect is one very clear example, where it comes from this sort of never again model where you want the international community to come in and to act in prevention and in anticipation of such international crimes and atrocious violence. The principle exists. The Global South has always sort of, when you look at its sort of exercise, has more or less been in support of exercise of this principle, but how it comes about and how it's implemented and when it's not implemented, actually. So it's the principle of omission, or the practice of omission rather than the practice of commission, which highlights the critique or the selective application again of this principle. And I think it's, as critical scholars, we just have to sit with that duality at the same time, understand that this cannot be criticized just for the sake of it, because it means a lot. It holds a lot of value, especially for victims and directly affected communities where there's really no other avenue left. This is one source of inspiration and hope, but at the same time, it needs to be challenged, and sort of the capture of by hegemonic forces, as you rightly pointed out, also needs to be called out at all times. So that I leave it to you with that. That's how I engage with it, and I know it's not very satisfactory or doesn't bring any sort of like clear responses, but I don't think there's that nuance can be missed at any point of time. Thank you.
I think messiness is something that we've all learned to live with. Are there either other contributors or other panelists who want to elaborate on this theme of sort of those dualities or those tensions in your own work before we move on? Feel free to just unmute and jump in if you do have anything to say.
Well, I mean, in a very different context, but I think I resonate the fact that what Professor Mehta mentioned, that we are always dealing with some sort of tension and dualities as TWAIL scholars. And the one that I face is, and I think it's central to how TWAIL is evolving, is on the one hand, if you're I focus on international investment law, but you look at any norms of international law, there is an inherent tension between pointing out the coloniality or the influence of imperiality on the very formation and content of an international law rule, but yet at the same time wanting to or having to engage with it so as to say that in a way that the same doctrines are understood more responsibly. And this itself creates a tension as to, if something's inherently so problematic, should we not just abandon it, or should we try to go for the best, not the best, but what they say, the best must not be the enemy of the good, that sort of an approach. But that's the reality that I think all TWAIL and so many of the critical scholars simply have to live with and find better ways.
I see a lot of nodding among the contributors, so a sense of sort of shared desire to improve the world without necessarily tearing everything down. As you all are well familiar, there's the critique, and then the critique of the critique, and we all, I think, junior and more senior scholars alike, have been navigating this question of sort of where to situate ourselves on that continuum, with part of the answer being, I suppose, how much we also want to participate in some sort of constructive endeavor. And I should also say that, my work is probably the most sort of mainstream among all of us, and yet I very much take these reflections to heart and struggle with them as well. So thank you so much for that reflection. And I know there are a lot of students in the public audience as well, and I'm sure they really appreciate your candor and sort of transparency about how we all struggle with these issues in our work. Professor Sen.
Thank you. I wanted to add to the conversation on duality, tension, and so on and so forth. One of the things that helps me make sense of this is the tension, a productive tension. And as I said in the introduction to the symposium, some of this work has been with the intention to restore the complexity that TWAIL actually carries, rather than the thinning that happens in a certain kind of reading. It is, at the end of the day, a structural critique, which means that some of these features and functions in here in the structure and the processes themselves, regardless of the various agents. And one of these things that Professor Chimni foregrounds in his work is talking about the state form, or the modern state form, in which the separation of the economic and the political takes place. Similarly, how the logic of capitalist expansion is closely entangled to that state form. So every time we talk about the logic of capital and the logic of territory, a lot of it has to do with how the state form presents itself. And one of TWAIL's continued concern has been to constantly point out how the post-colonial state has inherited some of these maladies. And we see that in Vinit's presentation, where these show up in different hegemonic forms, in different forms of imperial continuities, and so on and so forth. So in other words, this is to say that your question is, of course, a very pertinent question. It's a question that always lingers. And I find value in understanding whether the tension is a productive tension or an unproductive tension, as I said. So yeah, just my 2 cents on it. Thank you. What a rich discussion, though. Thank you so much.
And does that provoke any additional interventions, either by our panelists or contributors? Well, while you're thinking about that, let me turn to the Q&A. We have a question specifically for Vinit, so perhaps picking up on that idea of statehood that Rohini just foregrounded. So a question here with the fourth world approaches would be, are you specifically referring to groups within nation states, which may include, as you mentioned, indigenous groups, but perhaps also racial minorities, LGBTQ persons, and so forth? So is that what we're talking about when we're talking about internal colonialism by third world states? Is that a link that you would draw, or is that something else that you're talking about?
Yes, so basically, if we go by the definition, when the term fourth world was propounded, so it was propounded by George Manuel, who was at that time talking about the Aboriginals only. So it was restricted to Aboriginals at that time. But if at present, if we look at the TWAIL scholarship, then it includes everyone who is marginalized of the marginalized, right? So it includes the females. You can include in this, like the females, or as Professor Chimni highlights, that we can include the caste in India as well, and we can include the LGBTQ community where they in all parts where they are neglected, and we can include the minority, whether it be racial or religious or of any sort.
Well, that also makes, thank you. And that makes me maybe raise another point again for reflection among anyone who would like to weigh in on the theme of transnationalism that has emerged also in the 2 morning panels. And I think we've heard about this in a couple of ways. So we just heard from Professor Mehta about multinational corporations, which have, which cross borders in different ways and may sometimes use the fact that they do cross borders in ways to insulate themselves from accountability. We've heard about transnational elites. So Professor Sorna in particular, I think, really emphasized that point that we now also have transnational networks of elites for whom things like ISDS may be personally or professionally beneficial. And so, and then Eric Loflat, I think you highlighted in your piece as well, through the story of the Latin American experience, this idea of peoples and the popular will, and that peoples and states are not necessarily the same things, and that the nation state, and I think this goes to your point about the fourth world notion that the state can be a site of emancipation, but also a site of oppression. And so, our transnational networks, to what extent do you see them as emancipatory? And if so, in what context? And to what extent can they also, operate counter to the interests of the peoples whose dignity ultimately is at the core of at least, I think many of our conceptions of what international law should protect. So transnational networks, good or evil, or both. I put that to the group and feel free to unmute and jump in. Yes, Vinit.
Yes. So when we are talking about these transnational organizations, so if we look that this third world approach is basically limited to this dichotomy of North and South, right? And they are focusing majorly on the intervention or the oppression by the state. So, but when we jump to the fourth world perspective, then they are talking about the oppression or the exploitation in any form, right? So these transnational organizations are the next oppressor, because at the present time, the transnational organizations are running the capitalist society in one way or the other. So they are the next oppressor, and they are, when they are exploiting these marginalized people. So these marginalized can be anyone. So basically, in the capitalist state, so at the lower pedestals, these marginalized society are always at the lower pedestal, be it they are capitalist society or they are a socialist society. So in that context, we can say that the fourth world comes to their rescue, so that we can understand that how they are being exploited, and what is the place of oppression, and if their oppression is taking place, that who is the oppressor. So here also fourth world comes into picture to protect and to hold the transnational organizations accountable for their acts.
Would others like to jump in? Yes, Eric.
Oh, well, you all, and I guess going on that whole theme of the transnational, I think this really does get back to Professor Chimney's point earlier on, well, what's the logic of capital and its inherent transnational reach and propensity to expand. I think kind of getting back to this point on, well, what is the nature of the state, and is it oppressor, emancipator? Well, so much of that is just inseparable just from just that logic of accumulation as it exists in this transnational realm. And so much of this, I think, can really just be fleshed out just through specific examples. And I guess one that was relevant to the subject matter I was talking about is, well, the nation of Argentina, for instance, which was amongst the most successful entities in navigating these capitalist realities in the 19th century, but then did so in a way that, even relative to any basically every other Latin American state, just unbelievably brutal, well, against indigenous peoples, against the Afro-Argentinian population, whose treatment would highly likely qualify as a genocide under the current international legal standards. The big attempt it undertook to import so many populations from Europe, and really following in that settler colonial model of accumulation. Again, I think just that particular social structure, that kind of social space, it really was this response to these transnational networks. And then, of course, that raises the matter of, is there any sort of alternative transnationalism from below, the subaltern internationalism Professor Chimney was talking about? I mean, in many ways, of course, doesn't have that same power of transnational capital, but then without that, well, what else is there? And just so many examples of this just throughout the world, throughout history.
Professor Sen, I think you had some literature suggestions for those who are interested in digging into some of these dualities more deeply. And then while we're getting to that as well, a question from the Q&A about sort of typologies. And when we talk about TWAIL, we sometimes refer to different generations of TWAIL. You know, is the fourth world part of the focus of third generation TWAIL? In other words, you know, are we moving towards a different definition of TWAIL sensibilities or TWAIL approaches? This is a long question, I know, but I'll just mention some of the principles that Rohini brought to light in your introductory remarks. And again, a reminder to those listening that there will be a printed volume that will also include her written foreword. But you talked about, the goodwill and good faith that we bring to the table, that it's a non-hierarchical enterprise, and that we have a widening understanding of expertise. So maybe starting with you on literature recommendations and how you see these different generations of TWAIL, but then I'd love to hear from each of the panelists on sort of how you situate yourself as a TWAIL or TWAIL adjacent or TWAIL inspired scholar, and is there value to kind of tracing these different generations of TWAIL approaches?
Thank you. I'm loving the energy you're bringing to our late night session. I'm going to keep my bit short so that the panelists can respond. I had 2 reading recommendations for those who are interested in the question of how do critical approaches scholars address these dualities. One is Sandhya Pahuja and Luis Eslava's Everyday Lives of TWAIL. This is asking us to move from the institutional locations of law, as in capital letter law, to law in small places, and see how those could also be sources and sites of legal imagination. And the other one is Rob Knox's Strategy and Tactic, thinking of one as a short-term engagement with international law as it is, and the other as a slightly longer-term vision of incorporating different alterities. But I think the lesson from all of this is one wouldn't want to cede the terrain, both for strategic and tactical reasons, and also because, as you said, so much has also come from it. International law is not just hegemonic, it's a product of contestation, which is why you have conversations on self-determination, on transitional justice, and so on and so forth. So if it's indeed a space of that nature, it doesn't make sense to give up all of it, but one must strategize when dealing with structural inequalities. On the generational question, this is one of my favorite questions, some of this I respond to in the foreword, but my short answer to this would be, TWAIL is generational in many ways, and I think this generation's focus are epistemological concerns. The first generation, and all generations are circular. These conversations happen in each generation. Some get foregrounded, some do not. The first generation's concern has been with carving a space out in the post-colony. The second generation's concern has been pointing out certain structural limitations and continuations of imperialism. If this is the third generation, then the focus is fundamentally on epistemology. What are the knowledge frameworks that inform our understanding of international law and law? So that's my short answer, and I'll hand it over to the panelists. Thank you.
So we're a small enough group. Please feel free to just unmute if you would like to either, respond to what you just heard or situate yourself somehow in this broader framework.
Well, I can go first because in terms of the question that was specifically posed to Vineet, but I'll take the liberty of jumping in because I think it touches upon the points that we're discussing. I do think that there's a lot of value in vocabulary. Having a fourth world approaches to international law, for instance, allows you to highlight certain pressure points more effectively. But I do agree with the premise of the question that was posed, that it should be done in a way that it doesn't convey an impression that these are pressure points that have not been emphasized upon, for instance, by TWAIL scholars. And I think Sandhya Pahuja and Luis Eslava's work, for instance, talks about the difference between the people and the elites of even third world states themselves is something that TWAIL scholarship, as it has evolved over decades, also talks about, or it emphasizes about moving away from the discourse that focuses on state and instead shifting the focus to not just liberation and emancipation of third world states, but more importantly, third world people. So fourth world approaches, for instance, does bring a lot of, renewed enthusiasm and does highlight some excellent contributions that may have been overlooked, but it should be coupled with a caveat that some of these already are part of TWAIL, and that's something that TWAIL accounts for. So that's one aspect I just want to highlight.
Yes, that is what the conclusion of my paper as well, that fourth world cannot be separated from the third world approach, because when we are talking about the fourth world approach, it is not a altogether different premise which we are talking about. The basic premise is the same, but the focus, the basic premise that the fourth world is talking about is that we have to talk about the marginalized of the third world as well. So when we are saying that you can connect the third world to the fourth world, it is initially, or it is inherently connected, because the basic premise from where both these emanates is the same.
Would anyone else like to offer thoughts?
Yeah, I jump in now. Yeah. So firstly, to the I guess I don't even have the excuse of having a long day because it's just 7 here. But to come back to the question that was asked, I've written a book on it, by the way. A humble plug there on on strategic litigation and how to litigate or how to engage with international criminal law strategically, by which I try to highlight how to engage with or use the framework with the absolute consciousness and acknowledgement of its structural limitations, but not disregarding it and not sort of leaving the territory or terrain, but continuing to sort of challenge it and use it as a means of as a place for contestation, as Rohini very nicely articulated already. So I would probably also add that to your list of literature. But on the generation of scholars, I'd really find this like one thing that I always sort of highlight when talking about generations of scholars, and the distinction between, as Harshad also already said, the distinction between global South states versus peoples. And I find this discourse supremely helpful to sort of also articulate and it's important to articulate and not sort of miss that fact that we are in this point of TWAIL scholarship that we cannot sort of ignore the fact that in so many ways the post-colonial state has stepped into the shoes of the colonial master, and that needs to be questioned. And that colonial continuity in not only in the substance of the law, but also in the way law is being implemented and is being used, especially international law, if not, and also domestic law in some cases. And that I feel like that's where I situate myself in this sort of various generations. That's something that's key to, I think, how I look at TWAIL. Yeah. But thank you. That's just a very quick remark on that.
Well, this is precisely the place in which to highlight scholarship and work that will benefit all of us. So thank you for taking that opportunity. And I think what you raised also relates to a question that we didn't quite have time to focus on explicitly in the last session, which was precisely about, India and China in particular, that Professor Sorna had highlighted, but this idea that post-colonial states or formerly colonized states are, in some cases, even embracing some of the tools of oppressors. In his case, he was talking about, in particular, extraterritoriality, the Hong Kong national security law that China has promulgated. And so living, I think, with this complexity is something that we can all sort of struggle to do. I think we have maybe on that note time for one more sort of directed question from the Q&A, and that is also on the subject of ISDS reform. And so in the spirit of complexity, the question is, to anyone who would like to weigh in, but in particular, of course, to Harshad, what is your view of various proposals for ISDS reform, in the sense that ISDS may also have value, in particular, the protection of international investors from even democratic regulation. So the question is, what do you think about the current reform proposals and their impact on this ethos of protection of investors to the exclusion of the locals and local oversight?
Right. Well, I mean, it's a very loaded question, I must say, and a very difficult one to answer, views on which vary. I think my views, but there are certain common threads which shape my view, and I find it hard to contest them. The current reforms, in my view, I think I got it in the spirit of the question as well. I don't think the current reforms go as far as they should, and I would say precisely because of 2 reasons. Firstly, they stick largely to the assumption that the law is separate from politics. I mean, the entire motto of ICSID is that we're going to depoliticize investor-state disputes. And it's a claim that I don't think has, again, withstood the politics that ISDS itself has generated. So as long as any attempt at reform sticks to this paradigm and doesn't meaningfully try to look into different ways in which how politics affects the development of international investment law norms or their enforcement or their interpretation through ISDS, including, for instance, looking at which countries have historically had a disproportionate contribution in development of these norms, or what is the identity of ISDS adjudicators, and whether their individual histories and politics, how they seep into the educatory function. Unless a reform looks at these aspects, I don't think it would, in most cases, it would remain superficial, and in most cases may not regain the trust of those which are looking to abandon or revisit their engagement with the regime. The second point, and I think it's sort of linked to the first, is that any reform has to place ISDS at the very center of it, and in a very substantive way. Otherwise, it would again not be doing enough. And we have a very good example of it in terms of the modernization of the Energy Charter Treaty, which after years and years of conversation, in which many state representatives themselves participated, once you start noticing which states are getting sued more and are having adverse claims, you realize that it's the way investment treaties are interpreted and the awards are enforced, that is where the bite lies. So if you exclude that aspect, any modernization would not be enough. And we see with ECT, despite having undergone the so-called modernization process, states eventually decided, or the European Commission itself has now decided to exit the ECT regime because it's the ISDS that bites them. So there are certain commonalities which I think we need to look at for any reform to be effective. Although I will say, to borrow from Professor Olabisiokinkube's theorization about modern and radical critiques, I find somewhere myself in the middle, especially when it comes to investment law, because you have a David and Goliath problem, that there is no clear David and there is no clear Goliath. You can find instances where you have the bad investors and the transnational corporations, but you also have instances where it's the state that has clearly been abusing its power. And while investment law is not a perfect solution because it only protects a privileged class of affected stakeholders, at least for the time being, I think it is here to stay, and therefore reform is something that we have to deal with, as opposed to simply say abandon the regime, because I don't think that's happening anytime soon. Not in my lifetime is what my expectation is.
Well, one thing that TWAIL has certainly taught us, and perhaps those of us who are laboring in the fields of international law, is the close connection and sometimes the virtual impossibility of separating law and politics. And that's something that I think more and more domestic lawyers, at least in where I'm teaching, are coming to a realization that is also true in the domestic legal sphere, but certainly it's something that we've long been attuned to in the international legal sphere. So we're coming up to time for this panel before we turn over to our law review editor hosts for a couple of words as we pause for reflection and personal responsibilities before resuming again tomorrow. Is there anything that any of our panelists would like to say before we turn it over to Bharath and Shreyas, if he's here? Well, thank you so much to all of you, and thank you also for the wonderful questions from the public audience. Over to you, law review editors.
Am I audible? Right. As people would have noticed, I have changed into a sort of casual attire because it is almost midnight here in Bangalore. So I follow some of the scholars. Harshad was a professor of mine, investment law. Almost everything I know about it came from that one course. I truly think that this first day of the symposium has been a resounding success. I think most panelists and all attendees will agree with the extremely valuable takeaways we have had, and we have covered a lot of themes, a lot of which are better fleshed out in the contributions, the full-fledged contributions in the symposium, which will be out soon. And I am very certain that volume 35-2 will also start some sort of a discourse, ongoing conversation around TWAIL, law of jurisdiction, reforms of existing systems such as the international criminal law, the ICC, ISDS, etc., for a very long time to come. I am not as much of a TWAIL enthusiast as Bharat is, because I came up, I generally lean more towards mainstream international law, so I'll let him sort of finish the closing remarks on this and close out with his thoughts.
Had you asked me to speak?
Yeah.
I think he's
Awesome.
giving you
Yeah.
the last two words. Yes.
I don't think I have anything particularly new to say. It's just been very fulfilling. I particularly liked how generative the space was. And I think in line with the vision as well, just to see people who come from very different spaces come together and understand things. I think there's a particular joy in that all of us feel. There's a particular satisfaction in that. And that's been fantastic to witness. I also had the chance to read a lot of these pieces in the very initial stages, and to see it come into conversation and further develop is also very fulfilling for us. And our hope is that it is very fulfilling to all of you as well. And particularly about dualities, I think that's also a conversation I'll take home from this. I find Professor Simon Kidna's work very instructive in universal jurisdiction, because I think it's a concept that lacks clarity, and a lot of our scholarship actually gives us meaningful guide points to look at and carry forward. And again, just to see how it interacts with the critical space, and there is a chance of us being comfortable with the messiness and extract something productive from that is also something I think which will be a big takeaway of the symposium. And at the end of the day, I think I just want to thank everyone for their honesty, candor, and passion coming into this, because I think at the end of the day, all of us do share in some level a love for international law and many conceptions of it in all its diversity. And we live understand from each other. So thank you.
On a lighter note, before all the panelists leave us, I have it on good authority that the faculty here at the National Law School, especially some of the international law faculty, international economic law faculty, have taken a keen interest in this symposium issue and the discussion that has happened. So I would not be surprised if a new generation of junior students of mine were taught some of the pieces that are published in part of volume 35-2 or given as reading. Now, whether they like the reading load or not, I leave that question up to them. But I think that panelists should be very proud of that. Like, you've sort of added so much to that conversation.
Well, we look forward to seeing everyone who is able to come again tomorrow using the very same web links. And until then, be well. Thank you.
Thank you. Take care.